culprit. Every honest observer of the political scene knows that since the 1960s, the judicial branch, led by the United States Supreme Court, has accelerated its already well-honed pattern of usurping the authority of the elected branches of government. Constitutionalists like Mark and me believe that the judiciary should stay out of politics and policy matters. Federal judges, and especially Supreme Court justices, all of whom are unelected and unaccountable to the people, have rejected their constitutional role. They increasingly legislate from the bench and rewrite the Constitution at will. Liberal apologists for this kind of judicial tyranny glibly protest that but for the activist Supreme Court, we would still be living in the Dark Ages on issues from slavery to civil rights. But it was the court that upheld slavery and segregation, setting back race relations in America for more than a century. Every time the court arrogates power that was properly left to the other branches, it chips away at our constitutional foundation. Every time the federal courts issue rulings over internal matters of the several states, they do lasting damage to our system of federalism, and thus to the rule of law and to our liberties. Besides, judicial activists have a very poor record. They are the ones responsible for upholding such detestable and unconstitutional practices as slavery and segregation. When a small group of men and women donning black robes makes decisions beyond its authority, it is disenfranchising the will of the people, which is properly exercised through the people's duly elected representatives. This trend must be reversed before it's too late. That's why Mark has written this incredible book, to set out in layman's terms the current state of our runaway judiciary and the threat it poses to our nation. Mark takes us through all of today's hot-button issues and the way they are being shaped by the Supreme Court. In each chapter, he gives us the history of the constitutional development of these issues, so that we understand exactly where we are compared with where we started and where we ought to be. This book couldn't be more timely or important, as liberals continue shamelessly to thwart the people. Congress, the President, and state governments. Increasingly, liberals are also denying the President his judicial appointment power by blocking his well-qualified appointments purely for political reasons. While the informed public, informed primarily thanks to conservative talk radio, understands many of the issues involved in this book, Mark Levin's Men in Black provides an indispensable historical and constitutional context, and it offers suggested solutions to remedy the serious problems we face. Let me tell you, folks, this is a subject in need of our urgent attention, and this book provides the ammunition you need to defend your liberty. I am proud to endorse this book by a constitutional scholar, a brilliant lawyer, a pundit extraordinaire, an exceptional radio talk show host, a patriot, and my very good friend. I hope it sells 1 million, and that twice that many read, absorb, and take to heart its critical message. Preface. Men, not gods. The biggest myth about judges is that they're somehow imbued with greater insight, wisdom, and vision than the rest of us. That for some reason, God Almighty has endowed them with superior judgment about justice and fairness. But the truth is that judges are men and women, with human imperfections and frailties. Some have been brilliant, principled, and moral. Others have been mentally impaired, venal, and even racist. Barely 100 justices have served on the United States Supreme Court. They are unelected. They are virtually unaccountable. They are largely unknown to most Americans, and they serve for life. They work in a cloistered setting, hidden from public view. Yet, in many ways, the justices are more powerful than members of Congress and the President. The Supreme Court today is involved in nearly every aspect of modern life, regularly vetoing the decisions of elected federal and state authorities. As few as 5 justices can and do dictate economic, cultural, criminal, and security policy for the entire nation. So who are these justices? Well, it's impossible to generalize, but here are some of the more stunning personalities who have served on the Supreme Court. James Wilson. Wilson was appointed by George Washington in 1789. He had been one of the more influential delegates at the Constitutional Convention, but had serious financial troubles after he was appointed to the court. He put his money into land speculation, fell into serious debt, and was put in debtor's prison. He once had his son pay off a creditor so that he, an associate justice of the Supreme Court, could be sprung from jail in Burlington County, New Jersey. Hounded by creditors, Wilson later left his native Pennsylvania and had to live a life on the run. After holing up in a series of dreary taverns, he died broke in North Carolina and was buried in an unmarked grave. John Rutledge. Rutledge, too, was appointed by Washington in 1795 by recess appointment, and became the nation's second Chief Justice. A United States senator from Rutledge's native South Carolina wrote that after the death of his wife, his mind was frequently so much deranged as to be in a great measure deprived of his senses. There was considerable opposition to Rutledge's appointment, and he was voted down by the Senate. There had been rumors that his mind was unsettled, and he was becoming insane. Rutledge's depression was so serious that he made 2 failed suicide attempts, one shortly before and one soon after the Senate rejected his nomination. Henry Brockholst Livingston. Appointed by Thomas Jefferson in 1806, Livingston had killed a man in a duel before his appointment to the court. Henry Baldwin. Baldwin was appointed by Andrew Jackson in 1830. In 1832, it was reported that he was seized today with a fit of derangement. Less than 2 weeks later, Daniel Webster alerted a friend to the breaking out of Judge Baldwin's insanity. And another correspondent observed more pithily that Judge Baldwin is out of his wits. Baldwin was hospitalized for what was called incurable lunacy and missed the entire 1833 term of court. Baldwin's colleague, Joseph Story, informed Circuit Judge Joseph Hopkinson in May 1833 that, "I am sure he cannot be sane. And indeed, the only charitable view which I can take of any of his conduct is that he is partially deranged at all times." But Justice Baldwin nonetheless returned to active service on the Supreme Court, and remained a voting member of the court for 11 more years, until his death in April 1844 at age 64. Robert C. Grier. Appointed by James Polk in 1846, Grier suffered paralysis in 1867, and thereafter began a slow mental decline. Grier's case is most troubling because he was the swing vote in one of the most important cases of his era, Hepburn versus Griswold, which struck down the law allowing the federal government to print paper money. Grier's demonstration of mental incapacity during the conference discussion was such that every one of his colleagues acknowledged that action had to be taken. Nathan Clifford. Clifford was appointed by James Buchanan in 1858. After a period of mental decline, Clifford suffered a stroke in 1880, just before the beginning of the October term of 1880. Justice Miller described the situation bluntly. Judge Clifford reached Washington on the 8th of October a babbling idiot. I saw him within 3 hours after his arrival, and he did not know me or anything, and though his tongue framed words, there was no sense in them. Clifford kept his seat until his death in July 1881.